Yes, hi everyone. Today I will draw your attention to an issue of practical importance. When you are during the chief examination, where when you're about to cross-examine, and the witness the witness of the chief examination is going to offer adduce any evidence. Could be a letter, it could be some object, it could be anything basically that can be used for his case and against your client's case. Now you have the right to object to that evidence when it's first asked to be submitted to court, right, and become an exhibit. And you can do that when you think that the evidence is non-admissible. Now, it can be non-admissible. The evidence can be non-admissible based on various factors. One reason for this may be that it's irrelevant to the issues of the case. It's irrelevant to the facts that need to be proved in order to prove the case. It's not. In other words, it's of no use because even if it's admitted, it's not going to prove any facts that are relating to the issue at hand, to the relevant facts, the facts that need to be proved to prove the claim of that witness, of that party. So, if you think it is relevant, you're gonna have to make an objection. You can object to it when it's being admitted as evidence, or if it has already been admitted by a witness whose in possession that evidence was. You can and then another evidence, the evidence who had another witness, the witness who has created that piece of evidence is asked to come to court and testify in relation to that evidence. Then of course, when he's being asked during chief examination in chief, anything relating to that piece of evidence, you have to be quick on your toes to make an objection. So you're gonna have to follow through what is being said with a clear head, and that requires you to have you have to master the facts and have a very good inside knowledge of the intricate details of the case. So you're going to be able to pick up quickly what the witness is going to say and what he's going to be asked in order to potentially offer the contested evidence that you are going to contest. Now, you have to pay attention, right, on every single question when you're about to object to an answer being offered as evidence, or a question being questioned. So let's say that the counselor for the lawyer for that examines the witness asks him a certain question. When he asks that question, and you think basically that the answer given is going to be irrelevant or non-admissible based on certain reasons which relate to the law of evidence. You can stand up and make your objections, and the judge is going to ask you the reason for those objections, and you are going to have to justify the objections. You have to say why, for example, you consider that it's not admissible based on the fact that it's irrelevant, and why it is irrelevant. You have to justify that. And the judge is going to either sustain the objection, which means it's going to rule out this evidence and prevent, right, the evidence from being admitted. So he will not let him answer that question, or he's going to overrule it based on what the other party says or what he thinks. So he's going to let that evidence basically become part of the overall evidence that he's going to assess by the end of the trial. So two things you need to know. You need to master the facts, which means basically master the facts and pay attention to what is being said when you're going to raise an objection with regards to evidence being offered, right? And that's usually going to have to be before the answer pops up, because like you're gonna have to know the question to it. So before it pops up, raise your evidence, and that's basically the second thing I want to come down to. The second thing is basically be quick on your toes, be in a state of alert, and when the question, because sometimes the questions will come like, the question will be, even though the manner of the cross-examination is slow, when you are in that ring, in that arena, the battlefield of litigation, right, contentious litigation, a trial, then you'll be surprised at how simultaneously things happen, right? You have to pay attention. Like, some questions will be a lot more covert, right, and less easier basically to identify. Some lawyers are pretty good at asking certain questions structurally, constructively, without making it seem that they will be the testifier, the witness, is going to be giving evidence that is not admissible. So focus on the question. Focus on the question where it actually into the bottom. A seemingly noxious question might provoke a certain answer. So focus on the answer that may potentially be offered as well, be given. So you have to be in a state of alert, right? He may be asking bits and pieces, like little questions. However, if that question allows him to state anything that will have that will offer evidence which maybe in maybe within the range of what is admissible, then you should just stand up and raise your objection as soon as you can, as soon as possible. Otherwise, you should just kiss your objection goodbye, because the judge is not even going to allow you to argue why you should make an objection at a late stage, which is after the witness has offered the evidence. After he has offered the evidence, it's usually too late. So bear those things in mind, right? Know your facts and be quick to act. Thanks very much for watching. I'll see you all in my next video. Please subscribe to my channel.